to everyone who is joining us or just joining us this evening, has already signed on or is signing on. Welcome. We're going to get started this evening with Nancy. So Nancy, I'm going to just kick it right over to you if you are ready.
Sure. Welcome everybody. I'm Nancy Friedman. I am proud and privileged to be president of the Houston chapter of Americans United for Separation of Church and State and a national trustee of this great organization. I say I feel privileged not only to support Americans United and the great work it does, but also because I've gotten to know the national staff, including the people who are going to be on this call tonight. I'm sure you will, like I, find them to be not only smart and knowledgeable and well-spoken, but actually, let me tell you a couple of things about them that you may not know, but I have learned after getting to know them. In addition to that, they are very competent, they are very passionate and dedicated, and they are well respected by their peers, whether those peers are in Congress or on Capitol Hill, in the courts or sitting on the bench, or at other nonprofits. So I'm really happy that you all have the opportunity to do what I've had the chance to do for the last few years. This is a very unique opportunity we do have, and that is to get to listen to these three senior staff members of Americans United: Maggie Garrett, Richard Katskee, and Sarah Gillooly. Sarah?
Thank you so much. Richard and Maggie, if you'd go ahead and turn, whoops, your cameras on to join me this evening. Sorry, folks, I'm having one quick technical glitch, so I'm gonna solve that for myself and then we will get going. All right, thank you so much to everyone for joining us this evening. My name is Sarah Gillooly and I'm the Vice President for State Outreach and Engagement at Americans United for Separation of Church and State. And it is such a pleasure to be with you on the last night of Hanukkah, just a few days before solstice, a week before Christmas, and maybe we're already celebrating Festivus for the rest of us, for those of you in that camp. So just really pleased to be able to have this opportunity to bring you my incredibly brilliant colleagues to talk about what's ahead. You know, it has been 4 years. It has been 4 years. And it has really been a roller coaster, and we are happy tonight to be able to share some good and hopeful news about what's next in the future of church-state separation. Many of us are deeply exhausted. I'm sure that many of you have been working hard over the last few months to make sure that our democracy functions, that every vote is counted, and that we move forward together as a country. So we want to talk tonight about the election, the next court term, and answer questions that you have. We're going to have Richard and Maggie talk for about 30 minutes, which will leave a hearty 30 minutes for questions and answers. I want to offer you a reminder that we have the Q&A box, and that is down over in the bottom portion of your screen. Chat your questions there. We'll get to as many verbal questions as we can, and we'll also respond to some questions in writing if we can't get to all your questions tonight. So I guess I could also more formally introduce you to my colleagues, Richard, who is our legal director, longtime AU staffer, and Maggie Garrett, our vice president of public policy. Welcome to you. And Richard, I would really like to get started with you this evening, because what's been top of mind for me lately is what's happening in the Supreme Court and what's going to be happening next. I'm going to ask you to talk about COVID a little bit later on in the half hour, but I would love for you to start with a sense of what are we watching in the courts, the cases that we're watching as the court sits or comes back in January, although they're very active right now as well, and anything that you can say about the current court based on what we've seen so far. So Richard, I want to just turn it right over to you.
Sure. Thanks so much, everybody, for joining us tonight. Really pleased to be talking with you. And here's the apology. When you hear screaming and banging in the background, that's my kids. This is the price of life in this era of doing everything on Zoom. Listen, there's been plenty in the news about what Justice Ginsburg's death and the appointment of Justice Barrett mean for the Supreme Court. And of course, the Supreme Court is enormously important. I'm going to say a lot more in just a moment about what it's up to. But actually, before I get there, and I know some of you have heard me say this before, it's worth taking just a second to pay careful attention also to the lower federal courts. The reason is that's where most cases are decided. The Supreme Court decides about 80 cases a year these days. In the lower court, the federal courts of appeals, tens of thousands, and the federal trial courts, hundreds of thousands. So that's where most law is made by judges. Now, you know that 3 of the 9 Supreme Court justices are Trump appointees, but Donald Trump has also appointed almost a third of the judges on the federal courts of appeals and a quarter of the judges also on the federal trial courts. 233 federal judges in all, I believe, out of 870 spots. And he's still nominating and getting people confirmed even now after the election, when historically that just absolutely didn't happen. Who are these folks? 76% of them are men, even though for years law schools across the country have been graduating more women than men. More women than men have been entering the legal profession. 85% of Trump's appointees are white, not exactly reflecting the country. Looking behind those numbers a little bit, the White House has worked really hard to get judges likely to advance a distorted view of religious liberty, something that people who would curtail church-state separation, let religious objectors get out of following basic anti-discrimination laws, roll back civil rights protections, especially for reproductive freedom, LGBT people, but also for religious minorities and people of color, and the list goes on. Now, look, not all the Trump appointees are extreme ideologues who don't care about upholding the law, but many of them are, and it's by design. And by the way, they're young too, so they can dominate the federal bench for 30, 40, maybe even 50 years pursuing the agenda that they were selected for. And look, that's worrisome. It's really worrisome. But let me get to what Sarah actually asked about, is what's the Supreme Court doing right now? Here are some cases I think that are worth paying attention to. The first one is called Fulton against the City of Philadelphia. Now, Philadelphia, like state and local governments across the country, hires organizations, including religious ones, to investigate and certify people to become foster parents, care for foster kids in the state's custody. When Philadelphia learned that 2 of the agencies that it had contracts with wouldn't approve or work with same-sex couples, it didn't renew their contracts because, you see, Philadelphia has a law saying that prospective foster parents can't be rejected because of their race or religion or sexual orientation or some other considerations. So the agencies that the city hires to investigate and determine who's fit to be a foster parent are supposed to do that based on who's going to provide a safe, loving, caring home, not based on who we don't like, right? One of the organizations turned around and sued Philadelphia, saying that the free exercise clause gives it, now get this, a constitutional right to get a contract from the city to do the government's work of certifying foster parents, and a constitutional right to do that job according to its own religious beliefs rather than following the law, the rules of the program. The lower courts disagreed. The lower courts sided with the city. But the Supreme Court granted review and heard arguments in November, actually the day after Election Day, and we're expecting a ruling this spring or summer. This case is enormously important. Now, first of all, the court could decide to alter the basic legal test for free exercise claims. It's been asked to do that to make it so that if you don't like a law and your reason for not liking it is religious, you usually just won't have to follow it. Based on the justices' questions at oral argument, I actually think the court isn't likely in this case to go quite that far, though I'll tell you, Justice Barrett indicated that she really would. But I think the court is heading down that road, and it's frightening. What the court is likely to decide is that, at least for this case, Philadelphia can't require its contractor to follow the anti-discrimination law. Principally, I think the court will likely say, because the city also has other contractors that also certify foster parents. So if this one won't serve you, just go someplace else. Now, I have to say, that reminds me of the arguments about racial segregation in the 1950s and 60s. Lots of businesses and government officials and offices too said, hey, we won't serve you here, but gee, you can always go someplace else. And for lots of those businesses, the reason that they gave was rooted in religion. My faith teaches that the races should be kept separate, so laws that require me to seat and serve African Americans along with whites, they just can't apply to me. Those arguments failed then, and they should fail now. But I'm not sure that that's where our Supreme Court is these days. And by the way, if a government program or business can turn you away on religious grounds for being gay, it can also turn you away on the same logic for being Jewish or Muslim or atheist or for being Black or for having a disability, you name it, because the logic of that is just the same. That is not the way that things are supposed to work. You all know that and you all care about it. But the Supreme Court is likely to say, at least to some extent, that it is. Now, I'm going to tell you just a little bit about some other cases as well. These are ones where the Supreme Court hasn't yet said whether it's going to grant review, and we're waiting to find out whether they'll hear the cases or not. But they're all issues that the court has shown that it's interested in. And frankly, these days, that's not such a good thing. The first one I'll point to is called Arlene's Flowers. And this case will seem familiar to you if you know something about the Masterpiece Cake Shop case, the wedding cake case that the Supreme Court heard a few years ago. Washington State has a law that says businesses can't refuse to serve customers based on race, religion, sex, sexual orientation, and some other factors. A flower shop argued that it has constitutional rights to refuse on religious grounds to sell flowers for weddings of same-sex couples. The Washington Supreme Court rejected that argument twice. And actually, both times it did, it quoted from friend of the court briefs that we at Americans United filed to explain why that's just not how religious freedom is supposed to work. We were pretty proud of that. The flower shop, represented by Alliance Defending Freedom, ADF, a group you've heard us talk about, it's asking the Supreme Court to take the case and recognize a really broad right for businesses to refuse service to people on religious grounds. I have a religious reason for not wanting to serve them. I don't have to. If the court doesn't, even if the court doesn't take that case, I expect it'll take another one like it in the next few years. This is scary too. Anti-discrimination laws are critical protections for minority groups and all of us. It's how we protect religious minorities and non-believers, LGBT people, women, people of color. Discrimination isn't supposed to become okay just because you say that you have a religious reason for doing it, but that's the question that's going to be presented. Then there's a case called Dignity Health against Mitten, comes out of California. A transgender man sued a Catholic healthcare system in California after one of its hospitals canceled his scheduled hysterectomy when it learned that he's transgender. The California court said that the state's anti-discrimination laws that apply to all the healthcare context say you can't do that. He's entitled to the same procedure as anybody else. The hospital network has asked the Supreme Court to overturn the state court's decision and effectively override the state's non-discrimination laws and healthcare protections. And again, what goes for protection of LGBT people also goes for protection of everybody else under civil rights laws. If religion is a reason to get you out of following the law, I think we're all in trouble. Another case that the Supreme Court is considering whether to take, Ricks against the state of Idaho. A construction contractor challenged an Idaho law requiring that you give your Social Security number when you want to be a licensed contractor. He says that Social Security numbers violate his religious beliefs. He's asked the Supreme Court to rewrite the entirety of free exercise law so that having a religious reason gets you out of following nearly all laws that apply to everybody and apply to everybody equally otherwise. I said earlier that the court could do that in Fulton, but in the foster care case, but I don't think so. I don't think they'll go that far in that case, but Ricks is waiting there right in line. It presents the question and it's going to be attractive to the justices. And then just two other cases I want to mention, in which employees sued their employers under what's called Title VII of the Civil Rights Act. That's the federal law going back to 1964 that bars employment discrimination. They sued after their employers didn't accommodate their religious practices to their satisfaction. They asked for, what they asked for religious reasons, certain days off and things like that, and they didn't get all that they wanted, so they sued. Now, right now, employers are required to do what's called making reasonable religious accommodations, that they're supposed to accommodate their employees' religious beliefs and practices, as long as it doesn't impose more than minimal costs or burdens on the employer, or really importantly, the other employees. Because you should be able to practice your faith freely if you so choose, but you shouldn't be able to force your coworkers to pay for it. Now, the Supreme Court will take one of these cases or both of them or one like it in the next few years, because 4 justices before Justice Barrett was appointed already said they're interested in doing that. The law right now attempts to balance the interests of employees who want religious accommodations with the interests of others who would be affected, burdened, harmed by having to give those accommodations. And it says all those interests matter and you got to take them into account. The court is likely to change that balance. It's a big question, how far it'll go, how it'll do that. Let me stop there so we can get on to some other stuff as well.
Yeah, thank you, Richard. And I'm sorry you lost my video there. I had a tech challenge and had to do a quick change on my earphones. Thank you, Richard. We're going to come back to the court in a little bit because I would like to hear from you about the COVID cases in particular. There's been a lot of activity, over the last couple of weeks, including today as well. So I want to come back to that. But Maggie, I want to go to you and talk a little bit about the presidency. We've been talking about the court. I want to talk about the presidency. And before we launch into what we're going to be able to expect from the presidency next year, after January 20th, I wanted to take a little bit of a look back and ask you to tell me about what's the state of play as Trump is leaving office, as President Trump is leaving office. He has about 20 days left in office, but we've been seeing a flurry of activity in the last couple of weeks. So where are we at now, and what do you think we're going to see just in these next 3 weeks?
Okay, sure. So first I'll talk generally about what he's done in the last 4 years, and then I will talk about what he has done in the last 2 weeks, which kind of feels like he has done the same amount of things in the last 2 weeks as the last 4 years. So essentially the Trump administration has turned the principle of religious freedom on its head. He has wrongly claimed to be a champion of religious freedom, yet he has also called for a, quote, total and complete shutdown of Muslims entering the United States. And he implemented his Muslim ban. He has favored conservative evangelical Christians over all others when it comes to access, when it comes to outreach, decision-making, policies. And he has manipulated religious freedom in unprecedented ways to sanction discrimination, deny access to healthcare, require taxpayers to fund religion, allow houses of worship to endorse political candidates. And we actually have an internal document that I cannot promise to share with you because it is very messy, but it lists about 60 different things that he has done that are really problematic on our issues that we need to fix. He has overturned rules that would prohibit religious affiliated foster care agencies to discriminate against potential parents and volunteers. He's refused to enforce the Johnson Amendment. He, along with Betsy DeVos, has prioritized public schools and funding for private schools over public schools. So we have all of those things that we need to take care of. But it isn't over yet. As Sarah said, we have until January 20th, and he's already, since the election, really pushing a bunch of things through. There were lots of regulations that were sort of in the works that, election hit, it's not looking good for him. And suddenly all of these things started moving again and being finalized. So last week, the Department of Labor finalized a rule that expands an existing regulation that allows religiously affiliated federal contractors to discriminate. So this is taxpayer funded discrimination by contractors. And so in the past, it was, there's a religious exemption we don't like. We think if you get government funds, you shouldn't be able to discriminate at all. But there was a Bush era rule that said that federal contractors could discriminate against co-religionists. So I'm Lutheran, so I could say I'm only hiring Lutherans. But they just finalized a rule last week that says, well, it's not just that you can fire Lutherans, right? I can give you a sort of a test and make sure that you're a good Lutheran. So I can decide which teachings and tenets meet my religion, and then I can enforce them on you. So this makes it a lot easier to discriminate against LGBTQ people, against women. So it could be things like, well, I'm not discriminating against you because you're gay. I am discriminating against you because our statement of faith says that you cannot marry someone of the same sex, and therefore you are violating that statement of faith. Or I'm not firing you because you're a woman, I am firing you because you are pregnant outside of marriage, those sorts of things. It makes it easier. And they also expand who can use the exemption. So it has been thought of as it being a religious exemption for nonprofit entities, and they are expanding it so it could be for-profit. So you could be a for-profit entity and say, I am religious, I get to discriminate. So that was last week. On Monday, he issued 9 rules all at once. And these are the faith-based rules that I'm sure you've heard us talk about. We've been talking about them since the Bush administration. It's taken many iterations. And these rules significantly change the existing regulations that govern the partnerships between the government and faith-based social service providers. So these are groups like World Vision, Catholic Charities, the Salvation Army, and the rules as finalized strip away religious freedom protections from people often vulnerable and marginalized who use government-funded social services. And it would expand exemptions, again, that allow faith-based organizations to discriminate against employees when they're working in government-funded programs. It makes it easier for them to get more exemptions. It makes it a little bit easier for programs to infuse religion in their programs if it's like an indirect aid program. Essentially what it comes down to is this, like the other rule, they are prioritizing these large corporate entities that take millions and millions of dollars in taxpayer money. So they are prioritizing what they would refer to as the religious freedom for them at the risk of people who are using the programs, right? So they're not interested really in protecting individuals from discrimination, whether it's religious discrimination, LGBTQ discrimination, et cetera. What they're really interested in, right, is like giving extra rights to these powerful, usually Christian organizations. So they came out, and then honestly, up until I got on the call, I've been working on comments. Dina is finalizing them now. I will be submitting them once I'm off this call. And it is for the Equal Employment Opportunity Commission, the EEOC, which is responsible for enforcing federal laws that make it illegal to discriminate against job applicants and employees. And again, all of these are like tied into the employment piece. They're also, again, making it easier to discriminate, say that you're religious, get out of non-discrimination laws, et cetera. So that's a little bit about what we're doing. But it's like, this is like hot off the presses, right? Like this, and they're
happening right now.
Yes, they're moving everything really fast. So this EEOC rule, they released 30 days ago, and like everything is due today. So we have been, really sort of running to get these comments in because they're pushing things so fast. So yeah, so you've heard it first. Our comments are going to be submitted within the hour.
Maggie, is it typical is it typical that in this like last month we see this flurry of activity in a presidential administration, or is this somehow atypical to the Trump administration?
So I would say that most administrations, right, they've been working on these things for years, so they're trying to push them through if they can get them through. I do think that this is a little over the top. The EEOC giving 30 days and having very little public comment period. The last time they did it, they spent, I think 6 years, had 2 separate rounds, years apart of input with different people who, stakeholders. And this time they essentially gave it to the commissioners. They had like 2 days, and now they're giving us 30 days. So they are rushing these things. Or like in the process of the other regulations, Normally there's a phase where you can go in and have a meeting and talk about these things. Our meeting was scheduled, they canceled, our meeting and then put the regs out the next day as finalized. So they are moving particularly fast to push these things through. And they're particularly terrible rules as well.
Mm-hmm. It's almost as if they thought they had more time to do all of these things that they promised someone that they would do. And sorry, Maggie, I'm veering a little bit from the questions I told you I would ask you. I am familiar vaguely with something called the Congressional Review Act, about like what happens at the end of a presidential administration being subject to easier review. Can you tell us a little bit about, like, are these regulations subject to that? Like, what is that, and are they subject to that?
Yeah, so there's this law that says that Congress can sort of, repeal, overturn these regulations if they're adopted within a certain amount of time, before the next president comes in. And so I think a lot of people were talking about, when projections for what's going to happen in Congress, being what's going to happen in the election, they were saying, well, if Biden wins, he will come in probably with a Democratic Senate, and we'll just use the Congressional Review Act, which has to be passed. If you want to do this, it has to go through both chambers of Congress. And so it might be more difficult to overturn these because the Senate as is not going to be interested in overturning these. So that takes away that. So all of the overturning will be harder, slower.
Got it. That makes sense. Thank you so much for explaining that to us. And so now moving into a forward stance, we're going to have a new administration, which means new opportunities. What's on your agenda? Like, what are you going to be asking the new administration to do for separation of religion and government?
So we have a top 10 list of things we want them to do. So this is for me, right? Okay. So for those of you who don't know, there's a common practice of DC advocacy groups, and they create like a blueprint. And you use it to share with the president, who's taking a new term, like what are your priorities? So we have a plan. Many of you have already seen it, and when I'm done talking, I can put it in the chat.
Got it there for you, folks. It's in the chat if you want to click on it.
And we're already meeting with transition folks and having conversations. And so we have, 10 points, right? And they can kind of be summarized as, first, repeal all of the terrible things that the Trump administration did and put forth a positive definition of religious freedom, and use that definition to create sort of, to forward that vision. And so, the first thing on our list is repeal the Muslim ban. The Biden administration has already promised that he would do that on day one. And then our positive vision of religious freedom is, exactly what you would imagine it would be. It is the idea that religion is a fundamental American value. It is the idea that the government should not take a position on any of these things. It is the idea that we are all equal regardless of our religious beliefs or if we are non-believers. It says that you cannot use religion to harm others. You can't use it to undermine non-discrimination laws or to take away healthcare. And so, in addition to that, we want him to put public schools over private schools. We want him to enforce the Johnson Amendment. And so those are some of the various things that we're asking for, and including, we're asking them to have people in the administration who know this stuff and who can understand it and, actually implement the things we're asking for.
Thanks, Maggie. And I'd encourage folks to click on the link. It's actually au.org/Biden agenda. We have a couple of different versions. If you're like me and you're like, give me the high points, we have a high points shortened version. And we also have a much more detailed version for those of you who are really interested in the intricacies of those policies and what we're asking for. And Richard, I want to go back to you to ask a similar question. Looking forward, I want to understand how you see the next administration, really starting first and foremost with COVID. Obviously, the pandemic isn't over, and we're going to be taking the pandemic with us into the new administration. So tell us a little bit about COVID, and then also any other hopes or dreams you have for the new administration.
Oh, sure. And by the way, folks, Sarah very politely and quietly, and will probably be upset with me that I'm saying, reminded Maggie and me both to slow down. Or at least speaking only for myself, I get so worked up because there's so much going on and also so much that we want to share with you because we know you care about it. But I'm going to try to make it so that you can actually understand what I'm saying. COVID. As the pandemic spread earlier this year, what we all know, have seen, and have lived with is states and local governments starting to put in place public health orders that limit, among other things, the size of indoor gatherings. Now, across the country, dozens of lawsuits were filed, mostly by houses of worship, some by religious schools, and actually some by gun shops or houses of worship and gun shops, seeking to prevent states from applying those restrictions to them. The overwhelming majority of trial and appellate courts initially rejected all those efforts to get exemptions from the requirements because they held that general restrictions on indoor gatherings can be applied to worship services and other activities at houses of worship just as much as to everything else. We at Americans United actually filed more than 40 friend of the court briefs in those cases to say that the proper legal standard, the proper legal test should be that houses of worship and religious schools ought to be treated the same way as comparable secular entities. As long as the government isn't subjecting worship services to stricter standards than analogous non-religious gatherings, things like indoor concerts and lectures, going to the movie theater, stuff like that, the restrictions are constitutional. And to begin with, the Supreme Court agreed with us. In May and in July, the court, both times by 5-4 votes, rejected challenges to what were California's and Nevada's restrictions. Chief Justice Roberts joined the 4 more liberal justices, which of course then included Justice Ginsburg, and the Chief Justice actually wrote an opinion saying exactly what we said. As long as religious gatherings aren't treated worse than comparable secular activities, that's just fine. He also said that the courts should generally defer to public health officials in figuring out health risks and deciding how best to prevent the spread of the virus. They're the experts, judges aren't. All well and good. But then enter Justice Barrett. The court has now reversed course and ruled for religious entities, with Justice Roberts, the Chief Justice Roberts, and the 3 more liberal justices now the minority. In a case called Roman Catholic Diocese of Brooklyn versus Cuomo, the court held that New York State had improperly singled out religion for worse treatment than other things, and so couldn't enforce its restrictions, gathering limitations against what were some Catholic churches and some Orthodox Jewish synagogues. Now, based on what did the court come to that decision? Well, what New York did was it went through and identified virus hotspots, the places where the transmission, the spread was really the worst. And in those areas, they, drawing circles on the map, they restricted activities more than in the rest of the state. And so, among other things, they restricted in-person worship services to 10 people, while they did allow essential businesses like grocery stores, depending on the size of them, potentially to have more than 10 people inside shopping and working at a time. What a majority of the Supreme Court said is that's discrimination because the churches didn't get the extra space and somebody else did, or that's one of the things the court said. Never mind that doctors and public health officials all say that grocery shopping just isn't like entering church with a crowd sitting in the pews for an hour or two and singing together and then hugging and all those things that people do. But the court said that the houses of worship didn't get the best treatment of anybody, so that's a problem. The court also has said since that decision that the lower courts have to go back and reconsider a whole bunch of their decisions, that it allowed gathering restrictions to be applied to houses of worship again, just like everything else. And so just the other day, for example, the U.S. Court of Appeals for the Ninth Circuit, which is the West Coast, said that Nevada's restrictions on gatherings couldn't be applied to houses of worship. And it's likely that other courts are going to file suit because that's sort of what the Supreme Court told them to do. I think it's pretty scary, particularly because there have been these super spreader events all over the country that are directly tied to go right back to in-person worship services. Now, what do these cases say about the Supreme Court in general and what it might be doing and where it might be going? Well, look, the court seems to be of the view that if houses of worship aren't treated better by the government than everybody and everything else, they're being discriminated against in violation of the Free Exercise Clause. Look, I think houses of worship shouldn't be treated worse than comparable secular activities. Of course they shouldn't. But they also shouldn't be treated better, particularly when lives are at stake, as they definitely are here. Not giving special preferential treatment to religion isn't supposed to be discrimination. It's what our Constitution requires and what the Supreme Court traditionally recognized it as requiring. Yet it doesn't seem like the current Supreme Court thinks that's the case. Okay, so Sarah, you asked also a broader question, which was how this relates to what the Biden administration will do. Well, and I'll start with COVID and then work kind of backwards from that. The Biden administration seems genuinely interested in sound science and listening to public health experts. Good for them, right? And that's what lots of state and local governments have been trying to do all along. Trump administration, not so much. So that will be a welcome change. But look, public health restrictions normally aren't done by the federal government because it's state and local governments that look at their own situations, like when New York went through and said, here are the real hot spots we have in the state, the real problem areas where we've got to take extra precautions. They figure out what the risks are, and we hope that they act responsibly. The federal government can try to exercise leadership, though a lot of that in this kind of context is done by, leading by example rather than imposing requirements. And by the way, speaking of leading by example, lots of religious denominations and houses of worship are being incredibly careful to protect people. Whatever the law is, they're bending over backwards to limit gatherings to keep their congregations and their communities safe. We're working with a bunch of those denominations, but some just aren't. The Supreme Court is ultimately going to get to say whether restrictions can be applied to houses of worship. And if they can't, a lot more people are going to get sick and go off and infect others as well. A lot of people are going to die. That's not what religious freedom is supposed to be either.
Thank you, Richard. It feels like one of the most sobering issues that's in front of the court, and one that many of us, myself included, are really paying attention to. Pivoting back a little bit to your hopes, even in the midst of the fears of how the court is going to treat the remainder of the COVID issues that it will have to address, what else are you looking for from the Biden administration, or what can we all be looking for or potentially even hoping for from the Biden administration?
So as the person who leads our litigation team at Americans United, I think obsessively about the courts. So I'm going to at least start there. There aren't vacancies on the federal bench right now because President Trump and Senate Majority Leader Mitch McConnell have filled them all. That's been their agenda. More spots will open in time. We don't know how many, but I certainly hope that when they do, President Biden and his team will pay attention to nominating people who understand the importance of church-state separation. Because look, think of all the issues we're facing. I'll start with traditional church-state issues. Are the public schools going to be open and welcoming to everyone? And are they going to be that's where our public money is going? Or are public schools going to favor and push the faith of the majority on everybody else? Are religious schools going to be getting the money that should be going to educate everybody in the public schools? Are religious entities generally now going to get government funding to press their religious agendas? Those are all in play. And then there are the biggest, most important civil rights issues of our day generally: LGBT rights, reproductive rights, healthcare, employment, you name it. All these fights are now going to be about religious exemptions. Why? Well, because the basic rights are pretty well established. And so if you want to fight against them, using religious excuses to get out from the laws, that becomes the mechanism that you have. So the questions are, do the rules barring discrimination simply not apply when businesses and government officials have religious reasons for, or offer religious reasons for excluding, shunning, and shaming disfavored groups and individuals? That's all going to be fought out. All those big issues are going to be fought out in our area of the law more than ever. So look, my hope and my expectation is that we'll start to find ourselves on the same side as the federal government in lots of these matters, and that little by little also the judiciary will begin to become a bit more balanced. I will love to be able to support the federal government's actions instead of suing over them all the time. I expect that will begin to happen, but we will always, even with a much more favorable federal government, still have to face the courts.
Thank you, Richard. You know, as an LGBTQ person, this issue of religious freedom arguments, so-called religious freedom arguments, being the way that those who oppose LGBTQ equality start to chip away is really frightening for me. It's really frightening to think that I wasn't able to get married. Now I am able to be married to my wife, but what aspects of my marriage are going to be weakened, are going to be taken away as the court starts to do this chipping from businesses and providers and government funded agencies. It is the thing that keeps me up at night, and really the thing that brings me and keeps me at AU to do this work. So I'm always grateful for what your team does every day in courts, big and small, around the country. Maggie, we've talked about the administration, the president, the outgoing and the incoming president. We've talked about the courts. What about Congress? What are we expecting from Congress?
So I'm sure you're all very aware that there are still 2 races in Georgia, and so that will have a big effect on what ultimately can be done in Georgia, or in the Senate and in Congress. But regardless of what happens with the Senate, the top thing on our agenda is the Do No Harm Act. I'm sure, again, you have heard us talk about the Do No Harm Act a lot. It is something that was really something that was created and introduced in large part because of AU. And so we're really, really proud of it. So what is the Do No Harm Act, for those of you who don't know? Well, it actually starts with RFRA. So many of the wrongs that have been done by the Trump administration are based on a misinterpretation of the Religious Freedom Restoration Act, which is called RFRA. And that is a statute that was enacted in 1993 with the goal of protecting religious liberty, especially the religious liberty of religious minorities. But RFRA is now being used to undermine civil rights laws and deny healthcare and to generally harm others. Most of the policies that you see from the Trump administration are rooted in this misinterpretation of RFRA, the waiver to allow foster care agencies to discriminate against people like Amy Madonna originally came as them saying that we're going to use RFRA to get rid of that particular provision. A lot of the hiring pieces are based on the idea that they have a RFRA right to discriminate, even though it violates the law. So much of this stuff is in RFRA. So this bill, what it essentially does is it says it restores RFRA to its original intent. It preserves the law's power to protect religious freedom, such as the right to wear religious attire and observe religious holidays, but it also clarifies that this law can't be used to harm other people. So it should be an interesting year because, it's a new Congress, so bills have to start anew. You have to reintroduce bills. And our co-sponsors, our lead sponsors, was Joe Kennedy in the House, and he is no longer in the House. And then Kamala Harris, who is no longer in the Senate, but perhaps maybe someplace more helpful, is Vice President, who can, push the Biden administration to make this bill a priority. So, but with no official co-sponsors, our first act is to get new co-sponsors. So we're working on that. I can't reveal anything about the folks who might take on these bills, but they will definitely be reintroduced. So we've got to get them reintroduced. And when we do that, we will be working to make sure that we have as many co-sponsors as we had last time. So we want to get a huge number. We will be working to increase our organizational supporters. We already have about 80, and we're going to work to try to get a hearing in the Judiciary Committee. So that is our main priority. And then otherwise, it will be a little bit easier for us on sort of the big picture things, right? Like, I'm not worried that they're going to pass a repeal of the Johnson Amendment, knowing that both the House and the person and the president would not support that, even if the Senate does. But we have to be a little bit more careful of small things. Our issues touch everything. You find them in, environmental bills. You find them in all sorts of places that people are not looking for. And so they pop up. And so we have to find them, and we have to convince sometimes people who have, created this entire bill knowing nothing about church-state separation, that they have to change their bill. So those are the things. Or sometimes it will be, as again, the government's about to shut down again. It might be shut down for this weekend. And we're working on, stimulus package money and private schools and those sorts of things. Sometimes, they're trading things back and forth to get something passed. And that's where a lot of things might get through. I mean, we won't let them. We'll do our best to not to let them.
And for everyone on the call, we will be coming to you in the new year to help us get those co-sponsors on the Do No Harm Act in Congress. There's not a bill yet, so you can't do it yet. You can't do it right now. But once the bill has been filed and introduced and has those original sponsors that Maggie mentioned, we're going to have to get all those co-sponsors. And the way that we get all those co-sponsors is by you, the constituents, and the voters asking your members to sign on. So we will absolutely be coming to you when the time is right, early in the new year, like in the first quarter or so, asking you to help us do that work of reaching out to members of Congress. So be on the lookout for that. It's incredibly important that we have the biggest number possible, which gives us the power and the strength to get a hearing, to get to that next step of advancing the bill. You all know, you don't pass a bill in a year, you don't pass a bill in 2 years, that these big changes to law take time. And so year after year, we have to march that bill forward. And this year, we're going to get a hearing on that bill. And we do that by having as many sponsors, co-sponsors as we can. We're going to go to some questions. I am scrolling through them and want to encourage my colleagues to scroll through them as well. If you have a question that you haven't asked yet, please pop it in the Q&A box. If it's in the chat box, we may not have seen it because we've been talking to you. So make sure it lands over in the Q&A box so that we can get to it. Maggie, I want to go to Alan's question, which is more of a political question, I think, than a judicial question about when, there's been these statements or threats, depending on where you sit, that progressives have talked about expanding the court. Of course, 9 is not a magic number. It's in fact not the number of justices that have been on the court since the beginning of the court. And so that number can flex, and progressives have suggested in some circles that we tack on a few seats, that the Biden administration tack on a few seats in order to change the balance of the court. Is that like a serious effort? Is that more like rhetorical and dreamy? What do you think about that?
That's a really interesting question. I think it was much more serious right before the election, when it was expected that the Democrats were going to pick up a lot more seats. And, as money was just flowing in right to those competitive Senate seats, and people really thought that the Democrats were going to pick up a ton of them. And I think that it was a real consideration. And people were trying to figure out what their position would be. A lot of people supported it who hadn't supported it earlier. Now with the Senate as it is, even if it's a Democratic majority, will they have enough people to do something like that? I think the answer is no. So I would say that for now, it's more of a rhetorical discussion. But oftentimes, as you all know, that it's those discussions that then become sort of the norm later on. And so I think we'll see.
Yeah, I hadn't, Maggie, thought about the fact that we heard much more about that prior to the elections, under the assumption that the Democrats would make huge gains in both chambers and there'd just be like overwhelming majorities, and therefore it would be easy to do that. And I hadn't really thought about the timing of that and why we're not hearing so much of that anymore. And that makes a lot more sense. Thank you. Richard, I'd love to go to the question from my fellow Floridian, Merrill, who is asking that given the current judicial environment, how do we, in our allied organizations, not bring bad cases or not avoid bringing cases in front of bad judges and giving them the opportunity to make bad law?
So look, this is what we're thinking an enormous amount about right now. And at the same time, which goes to another question, so I'll try to treat them both together, is when we're talking about religious exemptions, which is a defensive strategy to try to prevent those. Are there ways to go on the offense, as those of you who know about our Amy Madonna case? So here's the puzzle, right? A judiciary, and particularly a Supreme Court, that's very interested in religion issues, and not in a good way. But you have to deal with the fact that if you don't take steps to enforce the law that we have, you don't preserve it, it might as well not exist. So what do you do? Here's what we're thinking about and trying to do. A couple of categories of things to just give you a taste of. One of them is to look for places and ways that we can bring cases in state courts and under state law, because if they're under state law, the U.S. Supreme Court doesn't get to weigh in, and if they're under federal law but in state courts, the Supreme Court can, but is less likely to. There are a lot of favorable state courts and state judges, and it's not necessarily a blue state, red state phenomenon either. You got to look very closely into individuals and courts. And so that's one thing that we're doing is looking there. Another thing that we are doing is the question about going on the offense points to our case for Amy Madonna, which those of the folks on here probably know. If you don't, it's a case about foster care where we represent a Catholic mom who was refused to be a prospective foster parent by an agency that South Carolina and the federal government hire to do foster care placements in South Carolina, because she's Catholic and the agency is evangelical Protestant and doesn't work with Catholics or Jews or same-sex couples or Unitarians, or they've turned away a lot of people. One of the things to do in focusing on here's a situation where a Catholic mom is being turned away, that when you have a Supreme Court, which is, depending on how you count, either 5 or 6 Catholics and it's been Catholics and Jews. So I'm sorry, 6 or 7 Catholics now and 2 Jews, that we can show it's not, the people who are being discriminated against include, hey, people like you. It includes Catholics and Jews. Be aware, be wary of what you're recognizing as religious exemptions and how that allows people to be turned away, because a lot of folks get to suffer because of that. Justices who don't care as they should about LGBT people might care about themselves. They should have a bigger framework than that, but that they should at least have that. So that's another thing that we're doing. And I will point to one other one, which I have to be a little bit careful about because it's a little premature, but you should be watching pretty soon. There are ways that we are looking to even in cases that we haven't had already, as well as cases that we have pending against the Trump administration, to sue over regulations and governmental action that we think are bad and harmful, when we have some hope that when the Biden administration is confronted with the cases and has to look at them, it will make it a priority to, here's something the new administration should go through and change, so that it's not 187th on the list of priorities for all the various things that have to be undone from the Trump years, but that this is something that ought to be dealt with now. And so we're looking for and dealing with opportunities to do that as well. Those are some of the things that we're doing. There are more, but I think those are some of the more interesting ones.
Thanks, Richard. I want to go to Rhett's question. Rhett, thank you for joining us from SoCal today. So, and I want to ask a follow-up to Rhett's question after you answer Rhett's specific question. Rhett is asking us, is it a good sign that the Supreme Court tossed out Trump's request to invalidate those swing state mail-in ballots? Is the court distancing themselves? Can we know that? Like, is it good news? Can we hang our hat on like that? Is that a tiny bit of good news to hang our hats on?
Well, so I think it is a tiny bit of good news, but maybe not in the way that, Rhett, you're asking about. What I think it means is that the court had, when it entered into the 2000 election and chose a president, that left a really negative reaction to the court for lots of people, regardless, by the way, of whether they supported Gore or Bush, thinking that the Supreme Court was entering a field where it just didn't belong. I think it's a good sign that the Supreme Court is recognizing that democratic institutions, elections are supposed to matter, and that there's something a little bit weird when the court is stepping in and deciding things. Okay, fine. That's good. It's really good. But how does that transport into other categories of things? We don't know yet. I haven't seen reason yet to think that the court is going to have that broader interest in preserving our institutions rather than policies. There are people who do. I think the Chief Justice actually cares a lot about that, but I don't think there's a majority in the court that does any longer, and we'll have to see who wins that fight.
My follow-up question to Rhett's question is, I think it was early this week or late last week, the court denied cert or said they would not take up a case out of Oregon that I was watching very closely. Oregon has some laws in place that require schools to make sure that transgender children can use the appropriate and correct bathroom that matches their gender identity. And some parents sued, basically saying it was a violation of their fundamental constitutional rights and religious liberty to have their children be forced to use the bathroom with trans people. And I was really concerned about this case personally, and the court denied cert on it. So is there something to be read into that or not? I don't really know about the intricacies of how the court makes those decisions and if it means anything when they turn it down.
So I think this is also good, but qualified good. The first thing is, normally when the Supreme Court refuses to hear cases, it doesn't tell you very much, because from the justice's point of view, there's always another one coming that'll present the same issue. They can always wait. This is a case where if they particularly wanted to take that issue, they could have they would have. And it's a big relief that they didn't. But this goes back to the stuff that happened at the end of last term. And, you know, the sort of the big bright spot from last Supreme Court term was when the Supreme Court recognized that sex discrimination under federal law, or at least under a federal law, but it should apply to them all, includes discrimination based on sexual orientation and gender identity. So workplace protections that where the law says sex mean sexual orientation and gender identity as well. LGBT people get protected in work. This was a great decision. It was by 6 justices. Justice Gorsuch wrote it, and Chief Justice Roberts joined it, as well as the more liberal justices. But there's a funny little paragraph at the end of the opinion that says, but we're not going to talk about whether religious exemptions apply, that if the reason that you disfavor and won't hire or fire, or you fire or mistreat LGBT employees is religious, we're just not going to say that's a real thing to consider whether that gets you out of the law. So that was left as an open question, but with a big sign. And so that's worrisome. The fact that Parents for Privacy, the case Sarah mentioned, the court didn't take, underscores that they meant to be serious about recognizing and respecting the rights of trans people, or of LGBT people generally. That was meaningful, and that this court isn't going to immediately undo that. That's great. What are they going to do with religious exemptions? It all comes down to that.
There's no more important time to be doing the work that all of you, our volunteers, are doing, that Richard and his team is doing in the court, and Maggie and her team is doing in Congress and in state legislatures. We're out of time this evening, but I want to squeeze in one last question, because it's a question from our host, Nancy. And Nancy is asking about PPP funding. So this was a pot of money that was in the original stimulus package way back in the summer, I think, or late spring. It allowed all kinds of organizations and nonprofits to receive grant money to cover the salaries of employees during the economic crisis of the pandemic. But they were grant or loans that under certain conditions don't have to be paid back, which effectively makes them grants. And they were given, they were not, churches and houses of worship were not precluded from applying from that fund for those funds, which effectively means that for the first time in our country's history, taxpayer dollars were being used to pay the salaries of clergy and other religious leaders and other worship leaders. So Nancy is asking this question, noting that right in Houston, Joel Osteen's church got more than $4 million from the PPP fund. And are we going to continue to see these direct subsidies to houses of worship in the next relief bill? And is there anything that AU can do?
So this is a really difficult spot for us, right? Because it's unprecedented in difficult times, and we know that people turn to institutions, including houses of worship. We also know that houses of worship employ a lot of people. And so we really thought hard about sort of how to talk about this issue and what to do when this was coming up in Congress first. Plus, when that first CARES Act was moving and brought up, it went really, really fast. So we spotted this problem, right, of all of this money going to houses of worship. And so the first question is, right, like, can we say it can't go to houses of worship? And if you look, and Richard, you might disagree with me as I'm describing it this way, but if you look at Trinity Lutheran and some of the cases, right, like, you can't just say based on your status as a house of worship in a lot of these places that you can't get particular money. And so we really focused, and we did push back hard. We spent a lot of time talking to our allies in Congress. We wrote letters to the Small Business Administration about how they were going to implement this. And we said, you really can't use this to fund clergy salaries and to fund religious activities. Let's be honest, there's a pandemic and people are dying, and when we're saying we'd like you to change the law to make sure that this money is not going to clergy salaries, it did not make Nancy Pelosi's top list of things to do, right? And so, you know, we had a lot of allies in the House and the Senate Judiciary Committee making these arguments, and people are aware of it more than they were. Now, there's going to be more money that's coming out. We're expecting that there's going to be more money for PPP loans, and we are expecting that they're not going to change this portion of it. But to give you some good news, and I'm just being honest, it's a hard fight. It's not an easy one to win politically, or, you know, in the courts, right? So one of the things that we did is we really focused on the school angle instead. So we got information about who got the PPP loans. And when we started looking at the information, it was a ton of information. Sam Sokol from my department led this research, and we realized how many private schools were getting it. And so this was also right around the time that we knew that they were really pushing to put vouchers into the next pandemic bill. Now, granted, the next pandemic bill still has not been passed, but what we did is we created a report to show how much money private religious schools were getting. And that was a way to push back at vouchers and to push back at more direct funds going to private religious schools at the expense of public schools. So as we've been sort of fighting over this all summer, we made enormous gains in pushing back against money going to private school. We're expecting that there will be some money going to private school in the next bill, but it's going to be really narrow. It's going to have restrictions that they cannot use it for religious purposes. It's going to be specifically for like COVID response, whereas in the beginning it was like 5 different kinds of vouchers and all of these other things. And I know I'm supposed to make this fast, but I'm gonna tell you one more piece, which is, you know, so we're, you know, part of what we do is we send lots of emails around to offices and our allies. And so we're working with, you know, different groups as along with different legislators. So someone forwarded me an email at some point, and I looked all the way down, and one of the gang of 8, I'm not gonna say who it was. So it was one of our allies that said, like, please don't give this money to private religious schools. They've already gotten a lot of money. And they responded, and we were not on this chain. And it sort of got sent to us without anyone realizing it. They said, well, you know, Americans United did this report, and they demonstrated how much money they already got in PPP loans. And so we don't think that we should be giving them this ton of money that was already put in there. And so it was sort of exciting for me. So it's sort of a win on the PPP stuff, even though we didn't win all of it, but about how some of these things can make a huge difference. So a positive note to end it on, perhaps.
Thank you, Maggie. Nancy, would you pop your camera back on real quick? So if you're able, if not, maybe just your audio, because I would like to say thank you. It was Nancy and the Houston chapter who said, hey, let's do this. Let's get together and talk about what's next. And so to everyone who's joined us this evening, thank you. And to Nancy especially, thank you for the invitation to come and join your chapter in Texas and have this conversation. If there's anything you would like to say to close us out this evening, Nancy, please do. I want to let folks know that we'll have a recording of this evening. We'll have David from my team. Many of you know and love David. We'll have him edit the video real quick to cut out any blips, and then we'll pass it along to all of you. So Nancy, I turn it over to you to close us out.
I want to thank y'all, the great staff. I hope everybody on the call now understands why I'm so proud and impressed with our great AU staff. So I thank you, Sarah, Richard, and Maggie, for your great body of work, for your dedication to AU and our cause, and most of all, for giving us your time tonight. And Maggie, that is a great way to end. Again, that's impressive, and it must be very gratifying for you to know that some work that AU did made a difference, made it all the way through. So you're right, that was a great way to end. To everybody on the call, I think this went very quickly, even after Richard and Maggie slowed down. I think most of the people who joined the call at the beginning were just as interested as I, because pretty much everybody stayed on the call. But to those of you who are out there who join me in being proud of this organization, I hope you will also join me in renewing your membership. And if you aren't a member, joining. AU has reverted to renewing memberships at the end of the year. So you may have already gotten a membership renewal notice. If you didn't, please look for it and join me in making as large of a donation as you can to support the great work that is being done by the people we've seen tonight and their colleagues. Thanks for joining.
Good night.
Bye.
Thank you.